moot court competitions are very useful in terms of developing the skills of the students and also passing the message relating to the relevant subject matter. The Nairobi Center of International Arbitration has been very active in the recent past in handling matters that are relevant for the economy. Remember there was a conference not long ago I didn't manage to attend, but I wish to congratulate them for these activities. As Kenya School of Law, we appreciate partnership with institutions of like mind, and we hope that the session has been very fruitful to both the participants and indeed those who have been in the competition. So I would like to just welcome you to Kenya School of Law. This is your home, and you feel free, and as we interact, know that you are welcomed. So on behalf of the director, I just want to say, Karibu.
Professor Muigai was extremely instrumental in ensuring that the NCIA came to being. And for that, the NCIA will never forget, because it was like, at best, a bus stuck in the mud. And when Professor Muigai became the Attorney General, he ensured that bus was pushed out of the bus, cleaned up, revved up, and started moving. And you have all felt the presence of the NCIA. In that regard, I'd like to thank the members of the Secretariat for having organized this Moot.
It is indeed a very heartwarming experience to be here this morning to recognize two things that have happened over the last couple of years. First is the growth and strength of the Nairobi Center of International Arbitration. As the chairman has mentioned, all of us collectively worked very, very, very hard to get it into being. And we are privileged to live in a time when it has come into being. It is very busy. I have been there myself and seen its operations. I have handled a case or two from there. And I want to congratulate you, Lawrence, and the team. Keep up the good work. I also note that you are working closely with our neighbors. I was in Rwanda with you last month, and that was a good experience as well. We are not in competition, we are in collaboration. We want to create good, strong arbitral institutions in the region where we can cross-pollinate talent. I know you've been to Uganda as well and have had your interactions there. That's very important. And I see our colleagues are here today. I know that you are reaching out to Tanzania, a slightly different environment, but knowing your determination, I am very sure you will succeed. Secondly, I want to acknowledge the foresight of the organizers in bringing our participants here. I have looked at the moot problem, and it reminds me of when, as a young law lecturer, I used to teach a course in criminal law. And I would set a question on mens rea. And this question was, distinguish between offenses of specific intent from those of basic intent. I would then step back from the question and I say, it is a good question because even I can't answer it. I have looked at the problem that the participants will tackle this morning, and it is a very, very tough question. And I think that it is testimony to the level of sophistication that our own students are being exposed to, and that is absolutely critical. I was here at the school not so long ago, talking about, in another moot court, an Africa-wide moot court. And I was talking to them about the necessity for our students to step up to the next level of international legal practice challenge. When we came to the School of Law, it wasn't this one. It was another one up the hill near the Nairobi Hospital. It used to be a children's hospital in the colonial times. When we went there, the subjects taught at the School of Law were really bread and butter subjects. They were intended for the solicitor with his small little bag who would be practicing somewhere in Nyahururu or in Kashpul Kabondo. It was meant that he should have the Penal Code, Civil Procedure, the Evidence Act, and everything else he could remember from memory. Today, the world is very, very complicated. We African lawyers are being called upon to practice law at international forum and standards. And this moot court problem is evidence that our teachers, our lecturers, our organizers of these institutions recognize that that's where we need to be. I want to end by saying that I wish that the very, very best person and team should win.
Can I now ask the parties to introduce themselves?
My name is Mumbere Abraham, the claimants in this matter. For the claimants, agent for the claimants. We are Team RMP 06, and my colleague is Miss Kanani Daniela. Yes.
My name is Derek Kimani. And joining me today is my co-counsel, Sadi Israel Sadi, and counsel on hold and researcher for the purposes of this session, Ms. Jennifer Wanjeru Vital, with Team RMP 21. And we appear on behalf of the respondent, the state of the United Kingdom.
So we begin with the claimant. Claimant has 45 minutes to articulate your arguments. Respondent will have 45 minutes to articulate your response, and the claimant will then have 15 minutes for rebuttal.
In addressing you, we intend to address you on 4 issues. Firstly, I'll address you on the issue of jurisdiction, as to whether you have the jurisdiction to handle this matter. Then secondly, I'll address you on the substantive issue of expropriation, as to whether the United Kingdom, the respondent in this matter, expropriated Mr. John Foster McLean's investments. My co-counsel will then address you on the issues of national treatment, as to whether Mr. John Foster McLean, together with his investments, were treated in a manner in which the national investments, as well as the nationals of the respondent state, are treated. She will then thereafter address you on the issue of minimum standard of treatment, as to whether Mr. John Foster McLean and his investments were treated below the minimum standard that is set for treatment of foreign investors. She will then thereafter say our prayer and finalize our submissions. When addressing you on the issue of jurisdiction, I'll have particularly 2 grounds. The first ground will be whether this tribunal has, whether the claim of the claimant is within the scope of this tribunal's jurisdiction. That will be jurisdiction by reason of subject matter, by reason of the person, Mr. John Foster McLean, and then the ration temporis. After which, I'll address you on the second ground, which is as to whether there is agreement and consent to arbitrate this matter. When addressing you on the issue of expropriation, I'll have particularly 2 grounds as well. I'll address you on what expropriation is and whether the actions of the respondents amounted to expropriation. But then I'll thereafter show that the respondent state actually did not have the justification to expropriate Mr. John Foster McLean's investments. With that, allow me to give a factual background of this matter. In the year 2015, Mr. John Foster McLean, a national of the state of Canada having a free trade agreement between it and the respondent state, which commenced on 1st January 2018. In 2015, Mr. John Foster McLean came to the United Kingdom with the intention of setting up investments, and this was driven by 2 factors. The first factor is the existence of the legal framework and his belief that actually the United Kingdom will respect this legal framework. But then secondly, he was driven by the government of the United Kingdom giving him assurance of support in his investments. So having done that, he invested tens of millions of United States dollars in the United Kingdom, which involved him setting up 2 entities, the first being bedrock rubble mining and the second being crust mining. Having set up those 2 companies, he went ahead to set up infrastructure in the form of roads, as well as employing the nationals of the United Kingdom. This was due to an agreement that he and the United Kingdom signed. However, hardly had he gotten any profits from his investments. In 2018, the respondent, the United Kingdom, terminated the agreement they had with him, but then secondly, he was arrested and harassed, irrespective of the fact that the United Kingdom's courts of law had ruled that actually Mr. John Foster McLean had no fault. The state of the United Kingdom went ahead to put a halt to his operations, as well as dispersing his employees. It is due to this that Mr. John Foster McLean brings this matter before the Honorable Tribunal with 3 issues for determination. The first issue being whether the respondent state actually expropriated Mr. John Foster McLean's investment, but then secondly, whether Mr. John Foster McLean was treated in a manner below the minimum standards. Then lastly, whether Mr. John Foster McLean was treated in a manner that is contrary to which the respondent treats its own nationals. Having stated that, allow me move on to address you on the issue of jurisdiction, as to whether the honorable members have the jurisdiction to actually handle this matter. Firstly, I will raise a question as to whether this claim is within the scope of this tribunal's jurisdiction. Now, this tribunal operates under the rules of the International Center for Settlement of Investment Disputes Convention 1965. Thereunder, I refer to it as the Exit Convention. Under Article 25 of the Exit Convention, the jurisdiction of such a tribunal is given, and thereunder it is stated that it can handle a legal dispute that arises out of an investment between a national that is a party, a national of a party to this convention with any other party to that convention. Now, the respondent state, the United Kingdom, ratified to this convention in 1966, and Canada, the nation of the claimant, ratified to this convention in 2013. And therefore, it is not in contention as to whether these 2 states are parties to this convention. However, what is in contention is whether, firstly, Mr. John Foster McLean's investments are covered under the Exit Convention, but then whether they are also covered under the Free Trade Agreement between Canada and the United Kingdom. What is also in contention is whether Mr. John Foster McLean is a national of Canada and not a national of the United Kingdom. Now, I'll address you on the issue of covered investments. Now, investments are covered under the Exit Convention if they actually satisfy a criteria that was set by a tribunal sitting under the same rules, Salini versus Morocco. It was case number 4 of 2000. Now, in that case, 4 grounds or a criteria having 4 issues was set up. The first of this criteria is that there must be a contribution of assets by a claimant. Secondly, that this contribution must possess an element of risk. Thirdly, the contribution must be for a specified amount of time. But then lastly, that this contribution of assets must actually contribute to the development of the host state, that is the state that is party to such a dispute. Now I refer your honorable members to page 4 of the compromise, and particularly paragraph 6, line 5. It is stated thereunder that Mr. John Foster McLean actually invested tens of millions of dollars. Therefore, it is not in contention as to whether Mr. John Foster McLean actually contributed assets to the United Kingdom. On the same page, under paragraph 6, particularly line 6, it is shown that Mr. John Foster McLean actually contributed to the building of roads as well as to the employment of the nationals of the United Kingdom. It is therefore not in contention as to whether Mr. John Foster McLean contributed to the development of the United Kingdom. I'll again refer you to that same page under paragraph 5, particularly line 7, wherein it is stated that Mr. John Foster McLean invested in the United Kingdom in order to help it achieve its vision 2050. It is therefore the claimant's submission that he intends to invest until 2050. Therefore, it is not in contention whether he satisfies the criteria of duration of time. All this is evidence that Mr. John Foster McLean's investments are actually covered by the exit conversion. Now, these same factors are actually in the free trade agreement between the United Kingdom and Canada. And this is under Article 10(2)(7), wherein an investment is defined. And it is defined as an entity that possesses the characteristics of an investment, and these include contribution of assets, duration of time, and then an element of risk. Having stated that, I would also love to refer this honorable tribunal to a more recent case, which is Phoenix Action Limited versus Czech Republic. This was arbitration number 5 of 2006 before a tribunal sitting under the exceed rules. Now thereunder, 2 more factors were added. The first being that the investments have to be made in good faith, but then having been made in good faith, these same investments have to exist in a manner that is within the laws of the host state. Now it is a submission of the claimant that actually these 2 criteria are also fulfilled by him. Firstly, he invested in the United Kingdom in good faith to achieve profit, but then secondly, for a specific period of time, he intends to stop his investments after the expiration of that specific period of time. It is the submission of the claimant that he actually satisfies all these criteria.
What is the criteria for determining good faith?
Thank you so much for that question. Now, under that same case, it was stated that there will be good faith for as long as an agreement between the investor and the state actually shows or is agreeable between the 2 parties, and for as long as the investor goes on to fulfill what he promises under that agreement. Now, under that agreement that Mr. John Foster McLean has with the United Kingdom in 2015, he actually promises to contribute to assets. He actually promises to contribute to the development of the state, and these are all things that the claimant has shown to be doing. However, irrespective of that, good faith is on his side. However, there is bad faith from the state, because eventually, for no reason, his agreement is terminated and he is arrested. irrespective of the fact that the courts of law that are binding on the respondent state have actually ruled that he is being illegally arrested. I will now move on to the second ground under this.
Counsel, before you proceed, the claim you have filed is on behalf of Mr. McLean, is that correct? With whom were the lease agreements entered into?
Thank you so much for that question. I would love to refer you to actually paragraph 22 on page 7. Paragraph 22 on page 7. It is stated what Mr. John Foster McLean, what shares he has in these companies, as well as the percentages of his investments, as well as the agreement.
Before you move there, just confirm that the entities which were parties to the lease agreements were Crust and the UK company. Is that correct?
The legal entities. It is not Mr. McLean as an individual, is it?
Thank you so much
Yes.
for that question. Now, there are two agreements that Mr. John Foster McLean has with the United Kingdom. Firstly, he signs one on behalf of Crust, but then secondly, he signs one on his own behalf. And therefore, he brings this claim as an investor, having signed an agreement on his own behalf, but then secondly, being a dominant party in Crust as an investor, he has a percentage of 49% in shares and 80% in profit, according to paragraph 22. And therefore, he brings this claim in his own right as an investor that has an interest in Crust, as well as an investor that entirely dominates Bedrock Company.
Is there a distinction in the personality between Crust and Mr. McLean?
According to the laws of the United Kingdom, and I will cite for you a decision by the United Kingdom's Court of Appeal. It is Salmon versus Salmon. It is therein stated that there is a distinction between a company and its shareholders. However, I will also quote for you Exhibit 3 that is before you. This is the UK mining law, and particularly I will cite Article 5. Therein it is stated that an entity that is registered according to the laws of the United Kingdom cannot engage in mining activities. And therefore, it is the intention of this law that it should be individuals as well as foreign entities, and this is in accordance to Article 25, 2C and B of the Exit Convention. Foreign juridical bodies that are recognized thereunder that have the authority to engage in mining activities in the United Kingdom. And therefore, even when Crust has an agreement with the UK mining company, it cannot be having such an agreement on its own behalf, because the law in the United Kingdom nullifies such agreements. And therefore, such an agreement is signed by Mr. John Foster McLean himself. Having stated that, it is now a question before this Honorable Tribunal: is Mr. John Foster McLean really a national of Canada? Now, I'll recite for you, Honorable Members of the Tribunal, Article 25 2A, wherein a person of another state can bring this matter apart from the state that is before this tribunal as a respondent. Now, I'll refer you to the case of Marvin Roy Fieldman Kappa versus Mexico. It was Exit Arbitration Case number 1 of 1999. Therein, it was stated that in determining the nationality of a party, what has to be considered is the citizenship and not the residence of the claimant. Now, it is the claimant's submission that he is a citizen of Canada. Firstly, he's a citizen of Canada because under the Notable case, and this is a principle under international law, where there is a dispute as to whether a party is a dual national, then, and actually in accordance to Article 10.27 of the Free Trade Agreement between Canada and the United Kingdom, a person, the state that has a dominant nationality of that person shall be the state to take the nationality of that person. Now, under the notable case, what are the features for this tribunal to use to tell whether Mr. John Foster McLean is a national of Canada? And the factor that I want this tribunal to consider is the fact of habitual residence. Mr. John Foster McLean, according to paragraph 14, line 2, this is on page 6 of the compromise, has lived in the state of Canada for a period of 25 years. Now, having lived for a period of 25 years, he actually also satisfies the other requirements under the notable case, such as other requirements such as social connectivity, such as the existence of duties and rights reciprocal in nature between him and the state of Canada. It is a submission of the claimant that Mr. John Foster McLean is a national of the United Kingdom. Now, I'll go on to the third issue under jurisdiction. Was there an agreement and consent to arbitrate this matter? Now, in the free trade agreement...
Sorry, I'll take you back. Did you say a citizen of the United Kingdom or Canada?
Thank you so much. I said a citizen of Canada. It's a citizen of Canada. Thank you so much. Now, is there an agreement to bring this matter for arbitration? Now, under the free trade agreement between the United Kingdom and Canada, and particularly under Article 10.15 of this agreement, it is stated that each of the states agrees to bring a matter of this nature for arbitration. But then secondly, the consent of each of these states is implied under Article 10.16 of this same free trade agreement. And this free trade agreement is actually binding on the United Kingdom. And therefore, it is the submission of the claimant that there is agreement and consent to bring this matter for arbitration in the free trade agreement between Canada and the United Kingdom. Having submitted on this issue of jurisdiction, allow me now move on to a substantive issue of expropriation. It is a submission of the claimant that Mr. John Foster McLean's investments were actually expropriated by the United Kingdom. Firstly, what is expropriation? I refer you, honorable members, to a case that was actually arbitrated using the same rules that you are using of the Exit Convention. This is Bear Creek Mining Corporation versus the Republic of Peru. It was arbitration case number 21 of 2014. And thereunder, the honorable members adopted a definition of expropriation by Brian A. Garner in his Black's Law Dictionary, the 9th edition, at page 1123, wherein expropriation is defined as the actions of taking one's interest in property from him by a government. Now, honorable members of this tribunal, the claimant has already proved before you that firstly, his agreement between him and the United Kingdom was terminated illegally, as under paragraph 9 of the compromise. It's shown that the court actually of appeal of the United Kingdom that this termination was illegal. But then secondly, his property in the investments was also taken away from him and auctioned by the United Kingdom. Now this amounts to taking away of Mr. John Foster McLean's right in his investments, and therefore fitting within the definition of expropriation. Now, in the event that you find that there was expropriation, which I believe have proved that there was expropriation, then you have to ask yourself, was there a justification for these actions? And for you to see whether there was justification, I'll refer you to Article 10.6 of the Free Trade Agreement between the United Kingdom and Canada. And thereunder, 4 factors are given which the honorable members must consider. Firstly, you must consider whether these actions were in public interest. Secondly, you must consider whether they were done in a non-discriminatory manner. But in the event you find in the negative of these 2 factors, then you have to go to the third factor, which is, was there adequate prior compensation? Was there adequate prior compensation of the claimant? And then lastly, was this expropriation done with due regard to the law? Now it is a submission of the claimant that actually none of these criteria was actually satisfied by the United Kingdom when expropriating Mr. John Foster McLean's investment. It is therefore the submission of the claimant that, and actually his prayer, that this honorable tribunal should find itself as having the jurisdiction to handle this matter, but then secondly, should also find in positive of a substantive issue of expropriation.
Please address us a little more on the question of public interest.
Thank you so much. Honorable members of the tribunal, the actions of the United Kingdom or of any state that expropriates investments of a foreign national must be in the benefit, and I repeat, in the benefit of the public, those in the benefit of the nationals of that particular state. Now I refer your honorable members to the case of Técnicas Medio Ambientales TechMed versus Mexico. It was exceed case number 2 of 2000. Therein, a criteria to be followed was set in determining whether this was in public interest. And it was stated in that case that what must be considered are the effects of the expropriation on the measure of the investment. In other words, in determining whether the government's measure to expropriate is in public interest, the effects of such a measure to expropriate are what have to be considered. And by the effects, it is meant that the negative, there must be a positive implication that the public obtains from the expropriation of such an investment. And now, the respondent in the exhibits that is presented before us and before your honorable members does not show how the public is going to benefit when it actually terminates Mr. John Foster McLean's investment. In essence, what we know is that by terminating his investments, the United Kingdom's nationals are losing employment, and then the United Kingdom also is going to lose future chance of infrastructure development as well as contribution to its economy. And therefore, the effects of this expropriation are rather negative as compared to being positive. And therefore, this means that the United Kingdom does not do this in public interest.
How about the underlying purpose for which the national government undertook this action?
Thank you so much. The purpose for which the government of the United Kingdom expropriated these investments is actually not clear. In any event, the investor was not given any reason as to why his investments were being expropriated. What was to his surprise is that he was arrested, and even when he appeared before the courts of the United Kingdom, the courts of the United Kingdom actually saw no purpose in his arrest, as well as no purpose in the termination of his agreement. And therefore, that means that the United Kingdom had no purpose at all.
Counsel, on the question of termination of the lease, who terminated the lease?
Is it the government of the UK or the UK company?
Thank you so much. Now, the facts under the compromise actually do not show any other role played by the United Kingdom company after it has signed an agreement. Now, the moment it signs an agreement, having misrepresented to Mr. John Foster McLean that it will even give him a permit, what comes in are the state agencies, which include the Ministry of Environment and the United Kingdom Royal Police. And now these are entities and agencies that are actually attributable to the state of the United Kingdom.
What is the basis of attributing the termination of the lease between UK company on the UK government?
Thank you so much. I refer honorable members of this tribunal to a case, Jean Denal and Drenching International versus the Republic of Egypt. Now, this was case number 13 of 2004. Now, for the state to be attributed, two factors were set. Firstly, the actions performed by an entity empowered to exercise an element of the entity in itself must exercise an element of government authority, but then secondly, the act itself must be performed in the exercise of that authority. Now, it is a submission of the claimant that the United Kingdom, the Royal Police, was actually exercising its power with an element of government authority. The fact that under paragraph 9 of the compromise, Mr. John Foster McLean is actually even brought before the courts of law shows that all these actions were done in exercise of government authority. And therefore, this satisfies the criteria for actions of a state agency to be attributed to a state. But be that as it may, under Article 25, paragraph 1 of the Exit Convention, it is stated when describing what a state means, it is shown that a state party includes the sovereign of that very state, but also the agencies of that very state party. And therefore, all actions that are performed, firstly, by the United Kingdom Royal Police, by the United Kingdom's Ministry of Environment, even by the United Kingdom Mining Company, are actions that are attributable to the United Kingdom. With that, allow me invite my colleague.
Before you proceed, you're asking the tribunal to decide on the matter to do with whether there were adequate prior adequate compensation. Now, according to you, was there any compensation? Was it inadequate? How much was it?
Thank you so much. There was no compensation at all, and it is actually the basis of the claimant's case that there was no compensation, and therefore the minimum standards of expropriation that allow expropriation under Article 10.6 of the Free Trade Agreement are not met. And therefore, that's the basis of the claimant in saying that actually his investments were expropriated without justification and without following the letter of the law.
Without compensation, does that qualify to be expropriation?
Thank you so much. It qualifies to be expropriation without justification.
Chairman Ohaga and the honorable members of this tribunal, a good morning to you. My name is Kanani Daniela, as earlier on introduced, and I'm appearing on behalf of the claimant, Mr. John Foster McLean, and I'll be addressing issue 2, which concerns whether the United Kingdom breached the minimum standard requirement, and under this, it's our submission as the claimants that the UK actually violated this minimum standard, and I'll be demonstrating this under 2 major header amendments. Firstly, I'll be establishing the legal provision for minimum standard, and secondly, I'll prove the elements of minimum standard and show how the government has violated them. I'll move on then to address issue 3, which concerns whether the UK violated the national treatment as required under Article 10.3 of the UK-Canada Free Trade Area Agreement, and I'll do this still under 3 header amendments. I'll be establishing firstly what the legal provision for national treatment is. I'll go on to prove the elements of national treatment and conclude with showing how the government has violated that obligation. I'll therefore thereafter conclude my submission with stating the prayers on behalf of the claimant. If I may proceed to my substantive arguments.
Please.
Yes, Article 10.5 of the Canada-UK Free Trade Area Agreement provides that each state party shall accord to covered investments treatment in accordance with customary international law that includes fair and equitable treatment as well as full protection and security. And this brings me to the elements of minimum standard as required under Article 10.5, which is firstly, there has to be a covered investment. Secondly, that investment was treated in accordance with international customary law. Thirdly, that there was fair and equitable treatment. And lastly, that there was full protection and security. Article 1.3 of the Canada Free Trade Area Agreement, which is the Claimant Exhibit 1, defines a covered investment as that investment which was in existence at the time of entry into force of the Free Trade Area Agreement. Additionally, the same article under the Free Trade Area Agreements agreement defines exist as being in force at the time of entry. And it's our submission as a claimant that under paragraph 3 of the compromise, we see Mr. McLean making various investments in the United Kingdom. Additionally, if this Honorable Tribunal may make reference to paragraph 10, that is page 18 of the compromise, the respondents argue that at the time of entry into force of the Free Trade Area Agreement, the lease agreement had been terminated. But it's our submission as a claimant that basing on paragraph 9 of the compromise, we see that the UK police arrested Mr. McLean in May 2018, and it was as a result of his breach of the UK law, which they presume. And in Jan 2018, that's when the Free Trade Area Agreement came into force in accordance with paragraph 15 of the compromise. Therefore, it's a submission that our clients' investments were covered investments in accordance with the Free Trade Area Agreement. Moving on to treatment in accordance with customary international law. This is a requirement under Article 10.5, and it was interpreted in the case of Glamis Gold versus the United States, which is a unicitral arbitral rule award that was given on 8th June 2009, where the tribunal noted that Article 1105 of the North American Free Trade Agreement provides for the minimum standard of treatment of foreign investors to be similar to that given to aliens in a foreign state. And it's a submission that Article 10.5 of the Free Trade Agreement is in pari materia with Article 1105 of the NAFTA award, therefore establishing customary international law, which the respondents breached. Fair and equitable treatment is provided for under Article 10.5, Part 2A of the Free Trade Agreement, and it was interpreted in the exit case number 8 of 2005 in Packarin's Campaignet versus Lithuania, where the tribunal noted that for fair and equitable treatment to be accorded, then there ought to be established a legitimate expectation of the investor. And this legitimate expectation ought to be reasonable. It's a submission that looking at Claimant Exhibit 2, Part 8, Paragraph 1, it provides that Mr. McLean, when he entered into the lease agreements on behalf of his companies with the UK company, he was given a right to enjoy quiet possession of the area without undue government interference. But it's our submission that paragraph 9 of the compromise clearly discloses that the UK police got into the Portland quarry, arrested him, detained him for 3 months, went on to auction his property, which was a clear interference with his ownership of the lease area.
But Counsel, before you proceed, one of the requirements of minimum standard of treatment is fair, equitable treatment, which requires justice. Did Mr. McLean go to court? Did the Court of Appeal uphold his objection to his arrest? Did he get that?
Thank you so much for that question. Paragraph 10 of the compromise discloses that he actually went to the Court of Appeal and he got a judgment saying that he did not violate any of the UK laws. But if we move on to paragraph 11, we see that the UK police forced him to sign a concession agreement to terminate leasing in the Portland quarry. And since the Court of Appeal gave its judgment, our client has been deprived of continued investment in the Portland quarry, owing to the fact that even his workforce was chased away. So despite the fact that there was actually justice accorded, it was not sufficient and it's not visible. Moving on to establishing under Part 8 of the Claimant Exhibit 2, the lease agreements, it provides that for the lease agreements to be terminated, there ought to be a 12-month notice given. And if this Honorable Tribunal be persuaded by the decision of Middle East Cement versus Egypt, exceed arbitration case number 6 of 1999, the tribunal noted that for matters as serious as auctioning, then the investor ought to be given direct notification. It's a submission that nothing in the compromise discloses our client being given notice of the termination, and paragraph 3 discloses that this termination was done capriciously. It's therefore a submission that the respondents fell short of establishing fair and equitable treatment. As regards full protection and security, this was established in the case of American Manufacturing and Trading Company Incorporation versus the Republic of Zaire. It's an ICSID arbitration case number 1 of 1993, where the tribunal found the Republic of Zaire liable for falling short of the requirement to ensure full protection and security by failing to protect the investments of the claimant during the looting in Zaire. In the same vein, it's our submission that under paragraph 9, instead of the UK police according treatment to Mr. McLean's investment, it's contrary to that, violated it by arresting him, detaining him, disposing of his workforce and his selling his equipment, and it's our submission that this was not the required full protection and security. We submit as a claimants that the government fell short of the minimum standard requirement required under Article 10.5 of the Canada-UK Free Trade Area Agreement. And as regards national treatment, Article 10.3 of the UK-Canada Free Trade Area Agreement provides that state parties ought to accord to the investor of the other party treatment that is no less favorable and in like circumstances with the investors, the local investors in the territory. It's our submission that for one to establish national treatment, as was decided in the ICSID arbitration case number 1 of 1999, that is Marvin Roy Feldman versus Mexico, the tribunal noted that the investor ought to be a national of the foreign state. And as my co-counsel ably established, Mr. McLean is a citizen of Canada and therefore actually satisfies to be a foreigner in the United Kingdom. And these elements for national treatment were provided for in United Postal Services of America versus Canada. It's an ICSID arbitration case number 1 of 2002, where the tribunal found that if one relies on a violation of national treatment, they ought to show that firstly, this treatment by the respondent was given in accordance to an investment. That secondly, it was in like circumstances with another local investment, and lastly, that it was less favorable as regards the local investors. As regards...
Please address us on the question of less favorable than the local investors. What is the measure?
Thank you, Mr. Ohaga, for that question. The measure was established in Archer Daniels Midland Company versus Mexico, ICSID arbitration case number 5 of 2004, where the tribunal found that the state of Mexico treated Archer Daniels Midland Company in a less favorable manner by taxing their soft drinks more highly than that of the local investors, which gave the local investments unfavorable competition. It's our submission that if paragraph 10 of the facts shows that Mr. McLean, after receiving his judgment from the Court of Appeal, was denied continuation of his investments. And the compromise also discloses under paragraph 3 various injustices that Mr. McLean had to go through, which no other local company went through, owing to the fact that the compromise does not disclose that, and it's the very reason why we're before this honorable tribunal. Therefore, as the claimants, we submit that Mr. McLean went through this plight, and that is why he actually came before this tribunal to seek a remedy.
So the panel, in fact, has no comparison by which to measure Mr. McLean's treatment.
Thank you so much, Mr. Ohaga. If this honorable tribunal may be persuaded by the decision in Methanex Corporation versus the United States of America, it was an award given on 3rd August 2005, where the tribunal noted that for a comparison to be made between a foreign investment and a local investment, it can either be a matter of law or a matter of fact. And the tribunal in this case went on to establish that if an investor actually shows that as regards the law, there was a less favorable treatment given in comparison to other investments, then that would be sufficient to show a breach of the national treatment. It's our submission that as a matter of law required under Article 10.3 of the FTA, Mr. McLean has actually been treated in a less favorable manner because firstly, his investments were auctioned without notice given to him, as we have already established, that he was actually given a decision to show that he did not violate any of the laws, but the UK company and the government voluntarily and with an intention deprived him of continuing to make his investments in the Portland Quarry, and this was less favorable treatment. It's our conclusion, therefore, that we pray that this Honourable Tribunal will grant us a declaration that the UK has actually breached its obligations under the Canada-UK Free Trade Area Agreement, and we rely on the case of German versus Poland, which is the Permanent Court of International Justice decision given on the 13th September of 1998. Secondly, we pray that this Honourable Tribunal will grant compensation for £560 million for the damages caused by UK's breach of the obligations under the Canada Free Trade Area Agreement, and this is in line with the decision of ADC affiliate versus the Republic of Hungary, exceed arbitration case number 16 of 2003. Additionally, we pray that this tribunal will grant us more damages in line with the decision of Lemire versus Ukraine, exceed arbitration case number 1 of 1999, and lastly, grant us damages for the representation we're making for our client today.
Before we move on to moral damages and those secondary claims, please address us on the question of the quantification of your claim for £560 million.
Thank you so much, Mr. Ohaga, for that question. If I may refer this Honourable Tribunal to page 4 of the compromise, paragraph 6. Mr. McLean, who is our client, made various investments in the UK. He paved the roads, he got machinery, he got technical know-how, he got technology. And if this Honourable Tribunal will be persuaded by the decision of ADC Affiliate Limited versus the Republic of Hungary, exceed case number 16 of 2003, the tribunal actually noted that the issue of damages isn't a science. And therefore, as much as experts come through to quantify the actual damages, it's the discretion of the tribunal to arrive at a figure depending on the facts that have been provided before them. It's a submission that the compromise does not actually accord actual numbers or quantification for the loss our client made, but if we are to look at the impact that the actions of the respondent had on the investments of our client, they are worth the millions he spent. Additionally, if this tribunal may make reference to the preamble of the lease agreement, which is a Claimant Exhibit 2, we see that Mr. McLean actually gave a security of £50 million and £1 million to the ministry for his investments in the Portland Quarry. So it's our submission that the tribunal will put this into consideration in granting us the damages we seek.
But Ms. Kanani, you have given us a very specific figure. It has not been pulled from the air. Lead us to the number that you have arrived at. On the one hand, I hear you saying that the quantification is in the hands of the tribunal, because when you speak to discretion, that is the discretion of the tribunal, right? On the other hand, in your submission, your number is very, very specific. What is the makeup of this number?
Thank you so much, Mr. Haga, again for that question. If I may refer the tribunal to paragraph 22, that is on page 7 of the compromise, we see that Mr. McLean owns 49% of the shares in Crust, and 80% of the profits go to him. And additionally, in Bedrock, he's the sole owner of the company. It's a submission that basing on these percentages that he owns in the company, and also the millions of dollars he invested under paragraph 3, that this tribunal should actually give him £560 million.
In terms of time and space, that 560 million, is it the value before expropriation? Is it the value as at today, or the time we render our award?
Thank you so much for that question. Much for that question. If I may refer this tribunal to the North American Free Trade Agreement, it provides that for compensation to be given, there has to be a fair market value attached. And that fair market value is at the time of the expropriation. And it's a submission before our client's property was auctioned and expropriated. They were worth £560 million.
Mr. Chairman, we were promised by Council Abraham that a connection would be made on the issue of adequate prior compensation when we addressed on minimum standards. Well, we have not received any submissions in regard to that connection. Be that as it may, I feel that there is a risk that this claim may be premature, because what has been presented to us is a mosaic of activities. Yes, Mr. McLean put in the roads, he put in the equipment. The other part of the mosaic is there was the state arrest and the forceful act of signing the surrender of leases. And later on we're informed that there was a judicial reprieve for Mr. McLean. Now, what has been brought before this tribunal is the question of expropriation. When we look at the canvas and go through the mosaic, we have not been pointed to any section on the canvas where we are told that is the color of expropriation. It seems to me that this claim may be premature. What is your reaction, Council?
Thank you so much, honorable members of this tribunal. But I will refer this tribunal to actually a section actually Article 10.17 of the Free Trade Area Agreement between the United Kingdom and Canada. Now they are under factors of activities that have to be done before this a tribunal handles a matter of arbitration as said. Firstly, there has to be consent in the form of a consent certificate, but then there has to be negotiation as well as consultation. Now, this claim is not premature because firstly, there is consent that this claim comes before this tribunal for arbitration, but then secondly, there cannot have been negotiation, there cannot have been a consultation from the respondent state when the respondent state in essence does not want anything to do with the compensation and also hearing from the claimant, because as shown under a paragraph 9 of the compromise, even when the state is very on courts of law have made a binding decision on it that Mr. John Foster McLean's investments are actually being unlawfully terminated, the state does not want to listen. So now, there cannot have been negotiation with the state in the nature of such an environment, because if the state is not willing to be bound by its own court's decisions, then even when the claimant approaches it for negotiations, there cannot be a positive yield. So it's the claimant's submission that actually, much as there is no particular time when there is consultation and negotiation, this claim is not premature due to the fact that the Exit Convention, as well as the Free Trade Area Agreement, gives the claimant the mandate actually to come before this tribunal under the Exit rules if the state does not want to negotiate with the claimant.
Very well. Had you completed your submissions, Ms. Kanani?
Yes, I have.
You had. Remind us again what the basis of your claim for moral damages is.
Yes, our basis for the claim for moral damages comes from the decision of Lemire versus Ukraine, which is an ICSID arbitration case number 1 of 1998, where the tribunal noted for one to satisfy a reception of moral damages, then they ought to prove that there was a violation of their reputation and that the actions of the host state physically duressed the claimant. And it's a submission that from paragraph 9, we see that the UK police actually arrested Mr. McLean and detained him for 3 months, and that satisfies the requirement for physical duress. And the requirement for reputation, we see that Mr. McLean from the compromise is a renowned Canadian investor who actually comes to invest in the United Kingdom, and therefore restraining him and auctioning his property damages his reputation in the economic scene. So that is what we use to claim for moral damages.
So, remind us a bit, the contract was between Mr. McLean and the UK government or the UK company?
The contract was between Crust LLC and Bedrock.
Now, under this claim, how do you bring in the acts of the government as opposed to acts of the contracting party?
We bring in the acts of the government because if we may make reference to the preamble of Claimant Exhibit 2, which is the lease agreement, the Crust LLC and Bedrock LLC entered into the agreement with the United Kingdom. And paragraph 2 of the compromise shows that UK company is a mining concessionaire and an agent of the United Kingdom government. So that is how the attributability comes in.
So there was no need of you suing the UK government together with the UK company?
Thank you so much. There was no need for that because clearly the Claimant Exhibit 2 shows that the contract was with the UK government.
The other concerns about the 560 million pound that my colleagues I think mentioned before. You have not been able to establish, break down how you reached at that figure. Now you leave it to the discretion of the panel to decide that. But when you look at, I think Mr. McKenna has 40% of the shares. Now does that represent the 560 million? Or the 560 the entire investment in there? Because we need to see which are these other 51 shares. What's their role now? Do we give the 560 to Mr. McLean and leave others because the another shareholder has 51? So how do you portion the damages?
Thank you, Mr. Athanas, for that question. Paragraph 22 actually discloses he's entitled to 80% of the profits. And it's a submission if the UK, that's the respondent in this case, did not restrain his investments, he would have invested and reaped gain from his commitment of capital in the United Kingdom. Therefore, the loss he suffered is worth millions of dollars, but that does not limit him giving part of the money to the other shareholders.
So the 80% profit is entitled to, does that one stand for the 560 or the 560 for the entire investment?
For the entire investment he made.
So where is the 80% now? I think I would expect that if the entire investment is 560, then 80% must be less than that. Because there's a 20% that's supposed to belong to somebody else.
Could you please rephrase your question?
It's okay, it's fine.
Oh, sorry about that.
Yeah. Please carry on.
Sorry, Ms. Kanano, address us on the question of interest and what we should apply our minds on when you're determining what interest to apply.
The interest to apply.
Yes, one of your claims is for pre-award and post-award interest, correct? Correct?
One of our claims.
Yes.
One of your claims, yes, your prayers, your reliefs. Pre and post-award interest. Address us on the principles to take into account when making that determination.
Thank you so much for that question. For one to determine what interest should be given, then we'll make a submission that the claimant that this tribunal put into consideration the provisions in the North American Free Trade Agreement, which require that this interest ought to be in line with the fair market value of the investments.
What percentage are you supposed to apply?
Where do we get the rate? Where do we get guidance on what rates to apply? Whether this should be simple or compounded? How do we deal with pre and how do we deal with post-award interest?
Would you like to answer that question?
Assistance from your co-counsel?
Yes.
Yes.
Thank you so much, Honorable Tribunal. It is our submission that in determining the interest that we should apply, that you should apply, you refer to the laws of the United Kingdom, because this is where Mr. John Foster McLean has his investments. And therefore, the economic atmosphere in the United Kingdom, as well as the laws that are also the laws that attribute to the interest in the United Kingdom, should be put into consideration.
And what specifically are we looking at?
We are specifically looking at, firstly, the agreement between the United Kingdom and Mr. John Foster McLean and his investments, wherein it is silent. Then we are going to look at the financial acts of Parliament of the United Kingdom.
So what I understand you to be saying is we should look at municipal law for guidance. Correct?
Yes, thank you so much.
Okay. Very well. You have 3 minutes left. Do you wish to make any closing remarks, or shall we turn to the respondents?
We turn to the respondent.
Turn to the respondents.
Proceeding to the question of jurisdiction, it is the submission of the respondents that this tribunal lacks the required jurisdiction to hear and determine the matters brought before it. It is clear from Article 41 of the ICSID Convention that this tribunal has the authority and competence to determine its own jurisdiction. This was held in the case of Gustav F.W. Hamster versus the Republic of Ghana, an award of 10th June 2010, specifically at paragraph 143, that it is a crystallization of the customary international law principle of competentio de la competentio, which empowers a tribunal to determine its own jurisdiction. Moreover, with regards to the question of jurisdiction, the tribunal in Tokyo Stoikeles versus Ukraine observed that the requirements of jurisdiction provided for under Article 25 of the ICSID Convention is a mutually inclusive test. And as such, all the 3 requirements of jurisdiction have to be met in order for this tribunal to exercise its jurisdiction. Further, the tribunal in Paushok versus Mongolia, an award of 28th April 2011, specifically at paragraph 282, provided that in analyzing its jurisdiction, this tribunal should consider first the Washington Convention, which is the ICSID Convention, at Article 25, sub-Article 1. Secondly, the requirements of the specific contract entered into between the parties. Thirdly, the national laws governing the specific contract. And fourthly, the bilateral investment treaty that was entered in between the various contracting states. It is then the submission of the respondent state that first, this tribunal lacks jurisdiction rationale personae because Mr. John Foster McLean, for the purposes of this case, should be considered as an effective and dominant national of the United Kingdom, and as such precluded from claiming as against his own state, the state of the United Kingdom. Secondly, the respondent will advance the argument that this tribunal lacks jurisdiction rationale personae since the investment in question is not a covered investment as under the bilateral investment treaty, and it is not a covered investment as it does not comply with the laws of the United Kingdom. With regards to the first submission of Mr. John Foster McLean's nationality, it is a requirement under Article 25, sub-Article 1 of the ICSID Convention that a party that seeks to, with regards to a legal dispute, a party that seeks to claim ought to be a national of another contracting state. In this case, then Mr. John Foster McLean is required to be a national of the United Kingdom, of Canada, in order to claim as against the United Kingdom. And as such, if he is considered by this tribunal a national of the United Kingdom, he is precluded from precluded from claiming as against the United Kingdom. The claimants, rather, in making their submissions, observed before this tribunal that Mr. John Foster McLean is a citizen of Canada. This is not in contention. However, it should be noted that Mr. John Foster McLean was born in the Isle of Man, and pursuant to Section 11 of the British Nationality Act of 1981, it is stated that an individual is an automatic United Kingdom citizen if he is born in the United Kingdom, its territory, or a former colony of the United Kingdom before 1983. It is clear from the fact pattern that the from the fact pattern and also from the FTA that the Isle of Man is considered a territory of the United Kingdom, and as such, by birth, Mr. John Foster McLean is a national of the United Kingdom by birth, and he, as it is stated at paragraph 15 of the claims, the statement of claims, he, having not claimed the United Kingdom citizenship, does not deny him his citizenship by birth. This tribunal, by considering Mr. John Foster McLean as exclusively a Canadian national, will be reaching a fatal conclusion that Mr. John Foster McLean did not have citizenship in the first place. However, it is the invitation of the respondent state to consider that Mr. John Foster McLean is first a citizen of the United Kingdom by birth, and secondly, a naturalized citizen of the of Canada, as he acquired this citizenship in 1970. Having established then that Mr. John Foster McLean is a dual national, I will guide this tribunal with regards to Article 10.27 of the Free Trade Area Agreement, which is Claimant Exhibit 1. And Article 10.27 of the...
Before you proceed on to taking us to that provision, Counsel, beyond the accident of his birth, what other connection does he have with the UK?
Thank you very much, members of the tribunal. That leads me to my submission with regards to him being a dual national by virtue of his effective and dominant nationality. Article 10.27 of the Free Trade Area Agreement provides that where an individual is considered to be a dual national, the test that ought to be applied in order to place his nationality is that of effective and dominant nationality. This is not a strange test, but a test that was established by the Permanent Court of International Justice in the case of Lithuania versus Guatemala, known as the Nottebohm case, where it was stated that where an individual possesses dual nationality, what ought to be assessed is his effective and dominant nationality. And in the United States-Iran Tribunal, specifically case number A/18 that was decided in the 19th of November 1986, it was stated that relevant factors ought to be considered in order to consider a person's nationality. These relevant factors include a person's prominence of a person's family prominence, secondly, his conduct of business, thirdly, his center of interest. These factors, members of the tribunal, have been met in this case. It is stated...
Are those factors cumulative? One discriminates the other?
They are not cumulative factors, but are factors that ought to be, they are factors that ought to be considered by a tribunal generally, but they are not cumulative factors. One may be met and a tribunal may consider that by virtue of that factor being met, then a person has effective and dominant nationality in a state. They are not cumulative factors. In this case, it is stated that Mr. John Foster McLean, at the statement of claim, that Mr. John Foster McLean obtains or gains interest to invest in the United Kingdom by virtue of the prominence of his family in the Isle of Man. Members of the tribunal, it is also seen that Mr. John Foster McLean invests in the United Kingdom with two vehicles, Crust LLC and BRL LLC. These vehicles have been incorporated in the United Kingdom. Moreover...
So, just to take you a step back, are you not dealing with an issue of lacuna in all the legislation you have addressed us on? And the lacuna is with regard to the forfeiture of birthright. Does any of the legislation you have brought to the table address the question of forfeiture of birthright, citizenship?
Thank you very much, members of the tribunal. The legislation brought before this tribunal, which is the British Nationality Act of 1981, does not provide for a forfeiture of nationality. It, however, provides for instances where a British national may, his nationality may be suspended. That is when the British national involves himself in acts of terrorism and when the British nationals involves himself in acts of espionage. In this case, it has not been seen that Mr. John Foster McLean has either engaged himself in acts of espionage or acts of terrorism to validate the cancellation of his British citizenship. In this case, members of the tribunal, it is the invitation of the respondent state that Mr. John Foster McLean ought to be considered first as a British national that has acquired Canadian nationality by virtue of naturalization.
But counsel, that is a choice Mr. McLean made, isn't it? It's a choice he made to be naturalized in Canada. It's a choice he made to be habitually resident in Canada. Should we ignore that by virtue of what you're saying, an accident of birth, which the chair addressed you about?
Thank you very much, members of the tribunal. And your question leads me to guide this tribunal with regards to the case of Champion Trading versus Egypt. This case involves two brothers that had been born in the United States. These brothers made their investments in the United States. However, one very interesting fact about these two brothers is the fact that they had been born to an Egyptian father. When this claim was brought against the Republic of Egypt, it was stated that these brothers were unable to claim as against the state of Egypt because due to the fact that they had been born to an Egyptian father in the United Kingdom, in the United States rather, they still remained to be Egyptian citizens who could not claim as against the Republic of Egypt. In this case, Mr. John Foster McLean is a national of Canada, of the United Kingdom by birth. However choice he makes to be resident in the in Canada, however choice he makes to obtain Canadian citizenship does not negate that he is indeed first as a national of the United Kingdom before he is a naturalized citizen of Canada.
So his choices are inconsequential?
Yes, indeed. His choices are inconsequential for this respect. Members of the tribunal, having discharged the burden that Mr. John Foster McLean is indeed a Canadian, should be considered for the purposes of this for this case, national of the United Kingdom, unable to claim as against his own state. Allow me then to address this tribunal with regards to the question of a covered investment.
So if we proceed, can you indicate us more now whether, you see the agreement was signed between Mr. McLean and the UK company?
Yes, indeed.
Now, did he sign under, do we consider it under the FTA?
Pardon?
Do we consider it under the free trade agreement?
Thank you very much, members of the tribunal. This agreement having been signed between the United Kingdom company and Mr. John Foster McLean should not be considered under the FTA, and that is the question that I will be addressing of the covered investment, which provides that the acts of the United Kingdom company cannot be attributable to this, the government of the United Kingdom, and as such do not in the first place constitute a covered investment under the FTA. With regards to the question of a covered investment, the claimants substantiated that the investments of Mr. John Foster McLean are indeed an investment as in accordance to the test laid out in the Salini versus the Kingdom of Morocco. However, members of the tribunal, this test was held not to be a conclusive test in the case of Bywater versus Tanzania and the case of Saluka versus Spain. It is therefore the invitation of the respondent to this tribunal that this panel ought not to be conformed to be guided by the test in Salini, because previous tribunals have held that the test in Salini of what constitutes an investment do not amount to a conclusive definition of what constitutes an investment. However, an investment ought to be examined not only in accordance to the Free Trade Area Agreement, but also in accordance with the domestic laws of the relevant state. In this case, the domestic laws of the various state in Claimant Exhibit number 3, page 3 at Article 2, it is provided that the minister is supposed to grant a license with regards to mining activities. It goes on to, at Article 10, page 4 of the Claimant Exhibit 3, that the conduct of exploration is to be done in accordance with the license issued to a person. Members of the tribunal, in the statement of arbitration, which the claimants have continually referred to as a compromise, members of the tribunal, and we would like to disagree, that this is a statement of claims of arbitration that is not an agreed set of facts. And that is why it contains a statement of defense and a statement of claim by the claimants. Members of the tribunal, in the statement of arbitration, at page 4, paragraph 8 and paragraph 9, it is stated that Mr. John Foster McLean's license is cancelled due to failure to obtain permits. Moreover, it is stated at paragraph 9 that the basis of Mr. John Foster McLean's arrest by the United Kingdom company was his failure to obtain permits and continuing to operate without these permits. Members of the tribunal.
One moment, sir. Whose obligation was it to obtain the license, the permits?
The obligation to obtain the permits was the obligation of the United Kingdom company,
which is owned by your client.
Thank you very much, members of the tribunal. The United Kingdom company is a state entity, and as I'll seek to submit, by virtue of it being a state entity does not necessarily mean that all its actions are governmental, are in exercise of its governmental authority. And in this case, the claimants themselves considered that Mr. John Foster McLean entered into the agreement with the United Kingdom company in exercise of its commercial capacities, but not its governmental authority. The case which they quoted of Jan de Nul versus the Arab Republic of Egypt provided the test that first, there ought to be an exercise of governmental authority, and secondly, the act itself ought to be put in scrutiny in order to establish whether this act was in exercise of its governmental authority or if this act was in exercise of an entity's commercial authority.
And where do we draw the line, counsel? Who is the beneficiary of the company's commercial activities?
Thank you very much, members of the tribunal. This question was also addressed in the case of, in the same case quoted of Jan de Nul versus Egypt, where the Suez Canal Authority that was established pursuant to the Suez Canal Act was involved in the management, effective management and running of the Suez Canal. These benefits that were arising from this effective and management of the Suez Canal were benefits that were going not only to the government of the Arab Republic of Egypt, but also to its citizens. However, the benefits test was distinguished from the functionality test. In this instance, the fact that the benefits of a certain actions are to the government or to its citizens does not necessarily mean that these acts ought to be construed as being acts of governmental authority. But in this case, it is the submission of the respondents that these acts were in pursuance of its commercial endeavors, and as was held in the case of BCG versus Yemen, an act that is held in pursuance of a commercial endeavor should not be considered as an act attributable to the state. Members of the tribunal, seeing that my time is far much spent, I will seek to invite co-counsel Tali Israel Tali to proceed.
Thank you. Thank you, co-counsel. Mr. Chairperson and members of the tribunal, as earlier introduced by my co-counsel Derek Kimani, my name is Tali Israel Tali, and within the next 27 minutes, I shall be guiding this tribunal with respect to the violations alleged of the FTA agreement, as well as the claim of valuation of damages alleged by the claimants. With respect to the violations of the FTA agreement, I will first seek to respond to allegations of breach of Article 10.6 of the FTA with respect to expropriation. Secondly, I will demonstrate that the claimant did not violate the minimum standard of treatment under Article 10.5. And finally, I will demonstrate that the national standard of treatment was not violated. I will then subsequently address the question of valuation of damages, whereby I will demonstrate that the claimant's basis of valuation of economic damages to amount to £560 million is not the appropriate basis, and secondly, that the claimant, Mr. John Foster McLean, is not entitled to moral damages. Should that explain the nature of my submissions, then I beg to proceed.
Thank you. Please proceed.
Mr. Chairperson and members of the tribunal, it is important at this stage to bring to the attention of the tribunal that the respondent's state case is based on two important factors and two important pillars that are submitted and substantiated by my co-counsel. First, the claimant, Mr. John Foster McLean, does not have a covered investment in the United Kingdom. And that secondly, to the extent that the alleged acts were done by the United Kingdom company, the United Co., members of the tribunal, those acts are not attributed to the state of UK as substantiated by my co-counsel. However, without prejudice to those earlier submissions, then, we will move and assess the question then of the acts which were done, by the Ministry of Environment as well as the UK Royal Police, as these are the only acts that are attributable to the state. With respect to the expropriation, members of the tribunal, allow me to first submit that the alleged expropriatory measures in question were determination of the lease agreements. In accordance with our submissions, determination of the lease agreements was done by the UK Court, acts which are not attributable to the state. Such acts therefore cannot be raised as a basis for claiming an unlawful expropriation under the FTA. Secondly, members of the tribunal, with respect to the acts committed by the Ministry of Environment as well as the UK Royal Police, it is the submission of the respondent that we indeed concede that the Portland quarry was shut down. We also concede that Mr. John Foster McLean was arrested. We further concede that Mr. John Foster McLean was not compensated. However, we submit, members of the tribunal, that the measures taken were regulatory measures that falls within the police powers doctrine. Members of the tribunal, the claimants correctly stated that the standard for a lawful expropriation is that one under Article 10.6 of the FTA agreement. Allow me to guide this tribunal that Article 10.6 of the Exhibit 1 should be read together with Annex 10B. Members of the tribunal, Article 10B allows a state to exercise regulatory measures as long as they are in accordance with the proper public purposes, they satisfy the element of due process, and that finally they are non-discriminatory. Such measures falls, as it was held in by the ICSID tribunal in Suez versus Argentina, they fall within the police powers doctrine. Therefore,
do I understand it to be legitimizing the actions taken by the police?
To the extent, Mr. Chairperson, that the acts taken by the police are alleged to substantiate an alleged expropriation, then we submit that the police acted in accordance with the regulatory measures of the state, which falls within the police powers doctrine.
Yes, so I repeat my question. Are you legitimizing the actions taken by the police?
Yes, I am seeking to justify the actions taken by the police.
How do you rationalize that with the decisions of the court?
Thank you, thank you, Mr. Chairperson. And it should also be understood to the tribunal that the Court of Appeal made a ruling that favored Mr. John Foster McLean. However, the claimant has mischaracterized the effect of the ruling of the Court of Appeal. The effect of the Court of Appeal, Mr. Chairperson, does not show that there were no breaches. The effect of the Court of Appeal ruling does not state that breaches were not committed. The effect of the Court of Appeal ruling does not show that the state was not exercising proper regulatory measures. However, the effect of the Court of Appeal are only to the extent of the regulatory breaches in connection to Mr. John Foster McLean. And therefore then, the question that arises, members of the tribunal, is, was the state exercising proper regulatory measures within the police powers doctrine? A three-tier criteria test has been set out in the celebrated case of Methanex versus United States, particularly at paragraph 7, that members of the tribunal, first, the measures taken must be for a proper public purpose. That secondly, the measure has to be non-discriminatory, and finally, that in taking the measures, due process has to be followed. When those three criteria has been met, members of the tribunal, then such measures will be considered to be non-expropriatory, and as such, there will not arise any obligation for compensation.
Are you saying we should disregard the Court of Appeal decision in respect of the Royal Police actions?
Thank you for your question. It is the submission of the respondent that the Court of Appeal ruling should be characterized properly. That the effect of the Court of Appeal ruling was not to the extent that there were no regulatory breaches. It could be that there were regulatory breaches, but however, according to the Court of Appeal, they were not attributable to Mr. John Foster McLean. Therefore, when the state was taking the actions it took, it was taking the actions in exercise of its regulatory powers. Therefore, we should not disregard. However, we should characterize the effect of the ruling of the Court of Appeal properly for the purposes of the present dispute. Members of the tribunal, I submit before this tribunal that the measures were taken for a bona fide, proper public purpose. This invites this tribunal to interrogate why were the measures taken. It is clear from the statement of claim, from the request for arbitration, as well as the statement of defense, members of the tribunal, that Mr. John Foster McLean was operating outside the Portland Quarry in violation of UK's environmental regulations. He was also operating without the proper permits. It is therefore clear that the actions were taken to bring the actions of the claimant in accordance with enforcement of the rule of law. The question that then arises is enforcement of the rule of law as a reason for taking regulatory measures a proper public purpose? That then invites us to interrogate what is a proper public purpose. Members of the tribunal, in the case of ADC versus Hungary, a proper public purpose was defined to include legitimate actions taken that have a benefit to the general welfare of the public, as opposed to a private individual benefit. Further, in ADC versus Hungary, the tribunal agreed with the respondent state, and indeed was quick to note that where the Hungarian government was taking measures to ensure that the actions of investors complied and harmonized Hungarian laws to the European law directives that Hungary had just acceded to, then such a measure could fall under a proper public purpose. Therefore, in that case, ADC versus Hungary, the arbitral tribunal agreed that enforcement of the rule of law can be a proper public purpose. In the present dispute, members of the tribunal, the measures were taken in enforcement of UK's environmental regulations, in making sure that Mr. John Foster McLean was within the limits of the domestic laws.
What happens to due process?
Thank you very much for your question. Then that now brings me to the second element: was due process met? A due process has been defined by arbitral tribunals to include. Due process has been defined by arbitral tribunals to include two elements, and of a major important element is the question that arises then: was the investor accorded an opportunity to challenge the measures in domestic procedures? Where, or the other question is, were the measures taken in accordance with the administrative and legal procedures in the domestic state? First, with regards to the question whether Mr. John Foster McLean was accorded an opportunity to defend himself or to challenge the measures in domestic procedures, it is clear from the fact pattern that Mr. John Foster McLean is accorded an opportunity, in fact, up to the Court of Appeal, whereby the Court of Appeal rules in favor of him.
Was that before or after incarceration?
The question of being accorded an opportunity to challenge the measures, a member of the tribunal, arises after the measures have been taken, because it's only after the measures have been taken that the claimant can challenge such measures in domestic procedure. So where the claimant is allowed an opportunity to challenge the measures under the domestic courts, then the tribunal is obligated to hold and find that the measures were taken in accordance with due process of law.
Don't you then render the FTA defective because a third corridor, so to speak, was created when the UK 2050 vision was created, documented? And it is that 2050 vision which invites foreign investors, and that is a promise by the state that they are aware of the special presence of Mr. McLean. Now, if you're asking us to superimpose the domestic standard, you're in effect shredding the FTA and all the exit convention rules which would apply to the investor status that was promised under the UK 2050 vision.
Thank you for your question, and it is the submission of the claimant that first, with respect to the domestic procedures, with respect to being accorded an opportunity to access domestic courts, we are not shredding the FTA in favor of domestic laws. However, we are submitting that it is a condition that for there to be a requirement that due process, which is a requirement under the FTA, has been complied with, then there has to be compliance, there has to be an opportunity accorded to access domestic courts. As in the present case, Mr. McLean was allowed an opportunity to challenge the measures in domestic courts. It is clear, therefore, that the due process obligation was not violated. Members of the tribunal, the final requirement then, therefore, is that the measures taken have to be non-discriminatory. Non-discriminatory in the sense that the measures taken not need to be targeted measures. It has been held in Metaclad versus Mexico that where measures are of general application, then such measures will not be considered to be non-discriminatory. In the present case, Mr. McLean was subjected to such measures because he was breaching the UK environmental obligations. That therefore brings to this tribunal to the understanding that the measures were of general application, that any other investor, even if it was not Mr. McLean, who was violating UK's environmental regulations, could have such measures undertaken to them. Having therefore substantiated, members of the tribunal, that the measures taken by the UK Ministry of Environment and Royal Police were in exercise of their legitimate regulatory police powers, then it is clear that the measures were non-expropriatory measures, and we invite this tribunal to hold that there was no expropriation at all and that there was no violation of the expropriation standard.
Counsel, before you proceed, should we ignore the sequence of actions? The summary termination of the lease by UK company, the summary imprisonment of McLean, the taking away of his assets and auctioning them. Should we ignore all that thread of actions as not being expropriation?
Thank you very much. And as earlier submitted by my co-counsel, and as I am substantiating, the acts here were not sequential acts, however, they were isolated acts. Isolated in the sense that determination of the lease agreement was done by the UK court, whose acts are not totally attributable to the state. However,
all those actions were targeted at either Mr. McLean or his companies.
Thank you very much. And for this tribunal to hold a violation of the expropriation standard, a member of the tribunal, there has to be measures that are directly attributable to the state. The state cannot be responsible for measures which were taken by UK court, determination of the lease agreement, measures which are not attributable to the state. However, with respect to the measures taken by the Ministry of Environment and the UK Royal Police in arresting Mr. John Foster McLean, then the sequence comes in that, members of the tribunal, the basis for Mr. John Foster McLean investing in the UK was the lease agreements. However, UK court terminates the lease agreements. That means that at the time the lease agreements were terminated, he lacked the proper basis for continuing on with the operations. He was obligated to stop the operations until he sorts out the commercial dispute or the contractual dispute with the UK court. However, he proceeds with mining operations without a proper legal basis, without the lease agreements. Members of the tribunal, then this invites the UK court to exercise regulatory measures because he was operating without any proper legal basis. And like it was noted clearly in 2018 by the Exit Tribunal in Kotek Mining, Kenya, and two others versus the Republic of Kenya, that where there is no covered investment, there can be no expropriation. The lease agreement had already been terminated. That has the meaning that there was no covered investment. That, therefore, members of the tribunal persuades this tribunal that the state was rightful in exercising the act it took in accordance with the Kotek Mining Kenya and two others versus the Republic of Kenya. Members of the tribunal, then, it is the submission of the respondent state that the respondent state did not violate the expropriation standard, and this tribunal should make a finding to that effect. This then brings me to address this tribunal with respect to the question of the minimum standard of treatment.
Before we go there, we agree, I think you said that what the state did was to, I think if I read what you, I consider what you said, the state doesn't consider expropriation. So meaning that the property of the Mr. McLean was taken by UK company, not the state, not UK government. Is that what you said?
We agree that Mr. McLean's property was auctioned by the state.
Why?
It was auctioned because Mr. McLean was operating in violation of UK's domestic law.
Now, if he, of course, the issue was about to regulate, he didn't follow the regulation of the country. Now, does that amount to auction the property? Of course, there are two things. There is the auction of the property. He's arresting him. Now, two things. If the police arrested him because he was working beyond because he was violating the lease agreement regarding the UK company, should they go ahead and auction the property?
The question then that arises is that the property.
Because the issue was about to regulate, he didn't follow the regulation of the country. Now, does that amount to auction the property? Of course, there are two things. There is the auction of the property. He's arresting him. Now, two things. If the police arrested him because he was working beyond because he was violating the lease agreement regarding the UK company, should they go ahead and auction the property?
That was auctioned was the property a covered investment so that the tribunal can assess it with respect to the FTA agreement? We submit that there was no covered investment.
Assuming there was no covered investment, must the state auction his property? Because you remember the agreement is between him and the UK company. Now, even if it is not a covered investment, must the state auction his property as a result of him violating the investment policies, regulations?
With respect to that, then, that will guide us to the lease agreements. The lease agreements allow the state government first an obligation to terminate the lease agreement, and after such terminations, the state has a right to auction the property as per the lease agreement, to be specific at page 20 of the lease agreements.
So are you saying that it is the state which terminated the lease agreement from your last statement?
Thank you very much. My statement was without prejudice to my earlier submission, and we still maintain that the lease agreements were terminated by the UK company.
Counsel, what I understand you to be saying is that to the extent that the lease had been terminated, therefore the investment ceased to be a covered investment. Is that your argument?
Yes.
The property that was auctioned, what was it the product of?
It was the product of the lease agreements.
Yes.
However, in light of Cortex Mining Kenya and two others versus Kenya, the tribunal was quick to note that sunken losses cannot be recovered. We will take the auctioned property to be part of the sunken losses. And in the event that there was already an illegality.
Why should you take now sunken cases? Sunken cases? Why should it be?
Because Mr. McLean continued with the operations in violation of the UK laws. That there was already an illegality. Where there is an illegality, then the investor cannot claim. There cannot be any legal basis of a claim where there is already an illegality. In the present dispute, there is already an illegality established. So
were there a due process of law before auctioning?
The facts are silent to that effect, member of the tribunal.
The claimant asserts that there was no notice.
He's supposed to be given a 12-month notice, which was not given.
Thank you for your question. Again, with respect to the claimant asserting that there was no notice and there was no legal and that there was no 12 months notice given, and that is a requirement, those are assertions which the claimants have not substantiated based on what law? The FTA does not provide for such a requirement. The FTA does not provide for notice. It therefore follows that it is in the hands of the host state when it has found that an investor is acting illegally to take the measures it can take.
Carry on.
Thank you, members of the tribunal. Then, with respect to the minimum standard of treatment, the claimants have submitted, and particularly the second counsel for the claimants, that there was violation of the fair and equitable treatment standard, as well as the standard of full protection and security. With respect to the violation of the fair and equitable treatment standard, the claimant went ahead to submit that Mr. John Foster McLean had legitimate expectations which were violated by the host state. Members of the tribunal, we submit that Mr. McLean did not have any legitimate expectations. This is based on the fact that, as it has been held in European Media Ventures versus the Czech Republic, a 2009 decision, legitimate expectations cannot arise out of an unlawful act. Like we have already substantiated, the acts taken by Mr. John Foster McLean were unlawful acts, and therefore there was no basis for any legitimate expectations. To the extent that Mr. McLean claims that he relied on governmental assurances of support as well as a governmental invitation, we invite this tribunal to be persuaded by the ruling in El Paso versus Argentina, whereby the tribunal was quick to note that that political statements and political invitations cannot give rise to legitimate expectations. We therefore submit that to the extent that the acts were unlawful, to the extent that they are relying on political statements, political invitations, then Mr. John Foster McLean did not have any legitimate expectations.
Counsel, do you equate policy statements with political statements? Our understanding is that this was a policy of the United States government to invite investment with a view to achieving Vision 2050. Are you suggesting that perhaps because this promise was made by one government and there's maybe been a transition to a different government, but therefore this was political? What's the difference between policy and politics?
It is important to assess whether the legitimate expectations herein arise from the policy statement of Vision 2050 as alleged herein, or what is the basis of the allegation. Then that will invite us to see what really persuaded Mr. McLean to invest. It is clear from the statement of claim that Mr. McLean invested relying on the lease agreements. The lease agreements were the major and primary basis of him investing. That one, therefore, demonstrates that to the extent that the lease agreements had been terminated already, to the extent that, therefore, the actions being taken were therefore unlawful, there was no legitimate expectations. The policy statement Vision 2050, therefore, we persuade this tribunal should not be in question in the present matter.
Lease agreements are legal instruments, are they not?
They are legal instruments.
Well, my understanding of the authority to which you refer is that it was premised on political statements. I'm still investigating that submission.
The political statements we are referring to are the governmental invitations and the governmental assurances of support. To that extent, we submit that governmental assurances of support and governmental invitations are mere political statements.
Is that how we should categorize all governmental action? As political?
Not really, Honorable Mr. Chairperson. However, in the present case, we invite this tribunal to be persuaded by that decision that I have cited.
Carry on.
Thank you, Member of Tribunal. And then I will quickly then move to address the question of whether there was violation of the national treatment of standard. And with respect to the national treatment of standard, it should be clearly established that, as was held in Methanex versus United States of America, particularly at paragraph 14, for there to be a violation of national treatment of standard, 3 factors which are cumulative have to be met. That first, a local investor should be identified as a comparator for the basis of comparison. That secondly, the local investor should be in same circumstances, similar circumstances as to the investor. And that finally, there has to be less favorable treatment accorded. Member of the tribunal, where the first element has not been met, where there is no local subject for comparison identified, then the whole claim of national treatment falls on that basis. This member of the tribunal then seeks to bring to the attention of this tribunal the question that did the claimants identify any local subject for comparison? Did the claimant identify any comparator? The absolute answer is no. Members of the tribunal, the claimants have failed, whether in the statement of claim or in their submissions, to establish any basis for comparison, and therefore the whole argument of national treatment standard false. The measures taken to Mr. John Foster McLean were taken to him not based on his nationality. They were not based on any differential treatment, because there is no local comparator in like circumstances.
Claimants concede that there is no comparator in fact, but they rely on the law.
The second counsel of the claimant was quick to note that there can be a violation of natural treatment of standard from measures either by law or by fact. However, this tribunal has to construe the meaning and effect of that statement. For there to be discriminatory treatment against the national treatment standard by law, that one means that the laws that govern the investment in themselves, in their nature, should be written and coded in the manner that they accord less favorable treatment to foreign investors. In the present circumstances, the claimant has failed to establish and demonstrate any local law that gives favorable treatment to local investors over national investors.
The three-judge bench made it clear that neither Mr. McLean nor the companies had committed any regulatory violations. Now, the court is interpreting the law. So their point is, on this question, we don't have a comparator, but as regards the application of the law, a three-judge bench has found the UK government to have been wrong. What is the response to that?
Allow me to begin by saying that, in fact, to the effect that the claimants concede that there is no local comparator, the whole submission of national treatment fails as the elements are cumulative. Now, with respect to your question, that the three-judge bench, which was interpreting the law, found that Mr. McLean was not responsible for any of the regulatory breaches alleged, we submit that the effect of the ruling, once again, should be properly characterized. The ruling should be taken, the government should be held liable for violation of other standards which, to the best knowledge of the respondents, are not protected by the FTA.
I think if you follow the claimant's position that the issue to do with somebody, any local company to compare with, for them it's not an issue. The issue is about the treatment that was given. He was arrested, his property was auctioned, and that was not accorded to other local companies. And thirdly, the courts went ahead to declare that that treatment was not necessary. It was illegal. Now, if the treatment was illegal according to the court, and if there's no any other company, a local company that was treated that way, according to the claimant, that was an issue to do national treatment. In other words, it was not treated the way it's supposed to have treated the local companies. Because this being a foreign investor from Canada, was given that treatment that was given to locals, based on the fact that the courts went ahead and declared that the acts of the police to be illegal in the Ministry of Environment. So I think that was the basis of submission on the issue to do with somebody to compare with, local company to compare with.
And we agree with respect to that submission. However, the major point and the important point for there to be violation of the national treatment standard is, members of the tribunal, there has to be a comparator. Where there is no comparator, regardless of the measures taken, however drastic and egregious the measures are, as long as there is no local comparator, then the whole test fails.
Okay, Counsel, we have understood you on that point. Please move on to the question of damages, because your time has run out, but we want to hear you on the question of damages.
Thank you. With respect to the question of damages, and to begin with members of the tribunal economic damages, it is the submission of the respondents that first, Mr. McLean is not entitled to any damages. Mr. McLean is not entitled to any damages with respect to the acts that were done by the UK court, as the acts are not attributable to the state. Under international law of state responsibility, a state will only be responsible for acts which are attributable to it. With respect of the acts done by the UK Ministry of Environment in shutting down the quarry and the UK Royal Police, we submit that the acts fall within the regulatory measures of the state, the police powers doctrine, and therefore the state, the police powers doctrine, and therefore, according to Methanex versus United States of America, where a state is exercising the police powers doctrine, there is no obligation of compensation that arises. However, should this tribunal hold otherwise? Should this tribunal find that Mr. John Foster McLean is entitled to damages, we submit that the 560 million pounds is not the proper amount and the proper damages quantified to be given. It should be noted that Mr. McLean, as has been stated in the fact pattern, invested tens of million pounds. Mr. John Foster McLean is claiming 560 million pounds. According to the statement of claim, he is alleging this on discounted future cash flows to determine the value of the investment at the present had the actions not been taken. Then therefore the question that arises is, what is the formula of quantifying damages? Members of the tribunal, there are two formulas to quantify damages, and the first formula is that one under the Chozu factory case that calls for full reparation, and the second formula is the HAL formula that is found in lawful expropriation BITs. The Chozu factory formula case only applies whereby the actions taken by the government were unlawful acts. And to that extent then, the state is supposed to pay full reparation, including the value of the investment that would have been had the actions not been taken. However, the HAL formula applies whereby the actions by the government are lawful measures. And therefore, the value of the investment at the time the measures are taken should be the value to be compensated. In the present case, like the claimants have, like the respondents have substantiated members of the tribunal, the actions taken were lawful actions, they were regulatory measures of the state, the police powers, and therefore the formula to be applied should be the HAL formula under lawful expropriations in BITs. Therefore, the 560 million pounds is not the proper damages to be assessed. However, this tribunal should look at what was the value of the investment at the time the investment was, the measures were taken. With respect, therefore, then to the question of moral damages, the respondents agrees with the claimant with respect to the standard of assessing whether the claimant is entitled to moral damages. And members of the tribunal, in Joseph Limer versus Ukraine, a decision of 2011, the tribunal noted a three-tier criteria, a criteria that is mutually inclusive, a criteria that is cumulative. And while establishing the test, in fact, it quoted the decision, the exit decision in the desert line versus the desert line case, and it stated that usually moral damages are not to be awarded unless in exceptional circumstances. So what are these exceptional circumstances? That there has to be an unlawful act such as an arrest as alleged or an unlawful detention, that this act has to cause physical duress, it has to cause loss of reputation, and that finally, this act has to be grave and substantial. Members of the tribunal, the question then arises, yes, we considered Mr. McLean was arrested. Mr. McLean was detained. But were the acts grave and substantial? Does every arrest, does every detention lead to a claim for moral damages? We submit that the claimants have not been able to establish any grave and substantial effect caused to Mr. John Foster McLean, and therefore the whole claim fails for not meeting the criteria set under the test as established by the claimants themselves. To that extent, we therefore submit that Mr. John Foster McLean is not entitled to any claim of moral damages.
The claimants say that he is a reputable businessman, well known in his community, and therefore has suffered reputational damage. What is your answer?
Members of the tribunal, the claimants have not established any positive evidence to demonstrate that Mr. John Foster McLean lost his reputation. The onus is then upon the claimants to demonstrate that he suffered loss of reputation. It is the position of the respondent that Mr. McLean does not lose any reputation. and therefore he is not entitled to the claim for moral damages.
On the issue of damages, we say that we rely on the police power doctrine, meaning that the police acted in the way supposed to, should have acted. Now my concern is, if you go by the court ruling, which declared that there was no violation of the regulatory requirements of UK, how do you still, based on the issue of the police power doctrine? Because what the police did was overturned by the court, meaning that the police violated the rights of the investor, Mr. McLean. So does that mean that he's not entitled to damages?
Thank you very much for your question, and allow me first to clarify to the tribunal how the police powers doctrine applies. The police power doctrine does not apply with respect to the police, the royal police, justifying the actions of the royal police. The police power doctrine applies as established in Methanex versus United States, where the state is exercising regulatory measures. Whether the acts were done by the police or the ministry is inconsequential. The question is, was the state exercising regulatory measures? And did the measures meet the three-tier criteria as I have substantiated? Where the three-tier criteria has been met and the measures are regulatory, then the tribunal will be obligated to hold that there was exercise of valid police powers doctrine. And where a finding that the police powers doctrine was being exercised lawfully and on a proper basis, then that will affect the quantum of damages, because it has been established that where a state is taking regulatory measures under the police powers doctrine, the state is not obligated to pay compensation.
Shouldn't we look at the police powers doctrine through the prism of legality? I mean, police powers can be exercised legally or illegally.
Thank you for your question. And for the police powers to be exercised legally, and for there to be a finding of whether the powers were exercised legally, the question will be, what are the conditions for exercise of proper police powers? That first, were they being exercised for a proper public purpose? Was due process followed? Were they non-discriminatory? Where the three-tier criteria has been met, then that will be legal exercise of police powers. In the present case, the measures were taken for a proper public purpose. The measures were taken in accordance with due process. The measures were non-discriminatory. Therefore, the police powers doctrine was exercised legally.
Why should the tribunal look beyond the decision of the Court of Appeal?
Like I've already submitted and substantiated, Mr. Chairperson, the decision of the Court of Appeal should be properly characterized in the present dispute.
So we should characterize it.
What is the effect of the Court of Appeal's decision? That is the question that this tribunal should ask itself. What is the effect of the Court of Appeal decision? Did the Court of Appeal in its decision say that that the state was not exercising regulatory measures? Or did it say that Mr. John Foster McLean was not responsible for the alleged breaches? It said the latter, that Mr. John Foster McLean did not, that was not responsible for the violations alleged. However,
what is the consequence of that? That finding that he was not in breach of any regulatory requirements, him or his company. What is the consequence of that on the question of exercise of police powers?
The consequence could be an oxymoron in the sense that
it's an illegality, is it not? The basis of the police action has been deemed to have been invalid. What does that do to the police action? Does it remain legal?
Thank you very much. The police action and the police powers doctrine are not one and the same thing, member of the tribunal.
Is one a subset of the other?
Yes. In assessing whether the police powers doctrine was applied, we will look at actions of various state actors, and that now will include the UK Royal Police. And in the present case, the Court of Appeal, in making its decision that Mr. John McLean was not responsible, did not mean that there were no regulatory breaches. It could be that there were regulatory breaches, only that they were not done by Mr. John Foster McLean. It could be that the person responsible for the breaches was the UKCO, because it was the UKCO which was tasked with obtaining the licenses. That could be the possible scenario.
Thank you, Counsel. You have run out of time. We will now turn back to the claimant and listen to their rebuttal.
Distinguish between the law of the arbitration, the law of the contract, and the law of the seat. It is a submission of the claimant that the law of the arbitration is what should be used in determining the jurisdiction of this tribunal, and the law of the arbitration is the Exit Convention of 1965 as signed in Washington. Secondly, Mr. John Foster McLean is a national of Canada. However, it is a submission of the respondent's agents that Mr. John Foster McLean should be considered as a national of the United Kingdom. The claimant does not contest his links to the United Kingdom as having been born in the United Kingdom. However, what the claimant intends to put before this honorable tribunal is that his effective nationality, effective and dominant nationality, lies with the state of Canada. And the agents of the respondents attempted to use the Interborn case, which was the ICJ case number 1 of 1955. However, the agents of the respondents did not fully satisfy the criteria as set in the Notabone case. Now, 5 major factors were set in the Notabone case in determining effective nationality. The first was the social factor of attachment. The second was the genuine connection of existence. The third were interests and sentiments. The fourth was habitual residence. And lastly, the existence of reciprocal rights and duties between a person and the state. Now, it is the submission of the claimant, as shown earlier on in the submissions that we gave, that the claimant satisfies most of these requirements with Canada as opposed to the United Kingdom. Firstly, habitual residence, which lies with Canada, having lived most of his life in Canada. Secondly, a social fact of attachment. A person who is born in the United Kingdom and then goes to Canada to live the rest of his life really has established his social life in that very state of Canada. Genuine connection of existence. It's genuine enough that being in Canada, the claimant has existed in Canada for all that time, 25 years. Interests and sentiments. Mr. John Foster McLean has interests in Canada. Majority of his investments are in Canada. Existence of reciprocal rights and duties. In the event that the United Kingdom decided that Mr. John Foster McLean should leave the United Kingdom, where will Mr. John Foster McLean go? He would go to Canada. He has a right with Canada. Duties. He has businesses in Canada. He has been paying taxes for a very long period now. It is our submission that the dominant and effective nationality of Mr. John Foster McLean lies with Canada as opposed to the United Kingdom. It was the submission of the respondent that they covered the investments of Mr. John Foster McLean are not covered investments. And in trying to bring this point to your attention, the respondent's agent submitted that the Salini test is not appropriate enough or is not substantial enough to guide this tribunal. The claimant does not contest that fact. That is why the claimant used, on top of the Salini test, used a case that is decided later on, the Phoenix Limited versus Morocco, wherein the extra elements of in accordance with the laws of the state and in good faith were put forward. Now, it was the contention of the agents for the respondents that the investments of Mr. John Foster McLean were not in accordance with the law. However, a question now should be answered by the respondent. Who determines whether laws have been followed in the United Kingdom. Is it the Queen? Is it the Prime Minister? No, it is the courts of law in the United Kingdom. Now, if the courts of law in the United Kingdom have decided under paragraph 9 of the compromise that indeed Mr. John Foster McLean followed the letter of the law, then who else should now question this fact?
Could we have your comment on the respondent's reliance on the Cortex, please?
Thank you so much. It is a submission of the claimant that actually the respondent misapplied the Cortex case. Now, Cortex Mining Company Limited and Sterling Capital versus the Republic of Kenya, exit case number 29 of 2015, was a case the respondent relied on it when it came to attribution. However, this was a case in determining whether the actions of these claimant companies were actually in accordance, or the investments were done in accordance with the laws of the Republic of Kenya. Now, in that case, it was held that these investments, a number of companies, had invested not following the laws of Kenya with regards to permits and licenses. It should, however, be noted that there was an extra element that court based on to determine whether the laws of Kenya were followed, which is different from this particular matter. Now, what are the differences? Firstly, in this case that we have before us, that your honorable members are going to determine, there is an agreement between Mr. John Foster McLean and an agency of the state. Now, this agreement is not in any way caused by any form of corruption. Now, in the Kote case, there was a form of corruption by a commissioner in the United Kingdom that illegally attempted to procure permits for these companies. Secondly, it should be noted that in the case before us, the respondent does not contest the fact that there were investments. In any sense, how could the respondent terminate agreements that he believes are not in existence? Because we believe you cannot terminate something that is non-existent. So it is the submission of the claimant that the Kote case can be distinguished from the facts that we have at hand, but in essence, it is in favor of the claimant, because in no way is it similar to the facts that we have before us. Now,
okay, we understand your distinction, but can you address us on the question which the respondent raised, that the expropriation took place after the termination of the lease, and to that extent, therefore, at that time there was no covered investment?
Now, I refer this Honorable Tribunal to Article 1.3 of the Free Trade Agreement. And what should be in existence, according to this article, is not an agreement establishing an investment. What should be in existence are the investments itself. Now, what this tribunal should ask itself, at the time when the atrocities are committed by the respondent, are there investments in place? And it is the submission of the claimant that the investments were in place when the United Kingdom actually committed these actions. And therefore, irrespective of whether an agreement had been terminated or not, of which the court in the respondent state actually determined that it was illegally terminated, but irrespective of that fact, what is important is, are there investments in place when these actions take place? Yes. I would love to finalize my submissions before I let in my colleague to continue by submitting on a question that you put before the respondents. The question was, what is the effect of the Court of Appeal decision? Now, under paragraph 9 of the compromise, it is shown that firstly, the Court of Appeal decided that Mr. John Foster McLean had been illegally arrested. But secondly, it decided that Mr. John Foster McLean's agreement with the United Kingdom had been illegally terminated. Now, the effect of that is that by stating that Mr. John Foster McLean's agreement had been illegally terminated, it meant that the actions of terminating that agreement are null and void ab initio, meaning that, therefore, that agreement cannot be considered to have been terminated. With that, allow me to invite my colleague to continue.
Thank you. Thank you so much, honorable members. I'll be responding to the respondents' response as regards minimum standard. And the respondents noted that the legitimate expectations of Mr. McLean were not valid and legal. However, it's our submission that this honorable tribunal will be persuaded by the decision of the European and Wales Court of Appeal in Esso Petroleum versus Madden, that was given in 1976, where Lord Denning, who was the master of rolls by then, noted that if a statement is made by a person of skill intending another to rely on it, and there's an actual reliance made, then if there's a breach of the duty of care that arises to fulfill that statement, then the person has the right to claim compensation. It's our submission that paragraph 2 of the compromise discloses that UK company was the mining concessionaire on behalf of the UK, and this gave it an edge of a skill as regards mining activities. And under paragraph 6, a UK company made a statement that Mr. Foster McLean relied on to commence his investments in the quarry, in the Portland quarry. Additionally, if the honorable members may go through to paragraph 7, line 2, we see that Mr. John Foster McLean adhered strictly to the terms that were given in the lease agreements, and therefore he waited upon the UK company to fulfill its part of the obligation on which reliance was made. And therefore that is why we are before this honorable tribunal stating that the fair and equitable treatment was not accorded to our client.
But, respondents make a distinction between commercial activities and regulatory activities. What's in the reliance that you that you submit on? Was it made within its regulatory ambit or within its commercial framework?
Thank you so much for that question. The reliance was made on both the regulatory and the commercial, because we see under paragraph 7, he adhered to the environmental impact assessment that is required under the UK mining law, and additionally, in response to the UK government's 2050 vision, he also made this reliance knowing that his investments would be adequately protected. But it's our submission that none of this was adhered to, and that's why we say that there was a breach for the fair and equitable treatment. The respondents also submit that for the national treatment to be there, they cited the case of Metanex Corporation versus the United States and noted that there has to be a local basis for comparison. But the respondent made reference to this paragraph in exclusion to the comment that the tribunal made that they can actually base on a matter of law if there's no factual evidence. And it's our submission that the compromise does not disclose any local investment that came up to make complaints of the respondent's actions, because there's no Mr. McLean, who is our client, suffered this plight as we had earlier established. So it's our submission.
What's your comment to what counsel submitted to the effect that the test is cumulative? The subjective test, whether you have a comparator or the law not being followed. What's your comment to the question whether it's consecutive or exclusive?
Thank you very much for that observation, Mr. Joffrey. And it's a submission as the claimant that still citing Methanex Corporation versus the United States, it was not a cumulative requirement for there to be a local comparison made by local a comparison made between a local and foreign investment, because the tribunal noted that in most instances it's very hard to get on the ground and get a local comparator to present before the tribunal. And it noted that where that arises, then that's when the tribunal will resort to the law and the legal provisions to establish if there was a less favorable treatment accorded. And if I may address the aspect of damages, the respondents state that for one to be able to claim damages, then they have to establish the formula, and they cited the HAL formula and the Chozo Factory case formula. And it's our submission that basing on their oral, all right, my time is up.
Thank you very much. Thank you very much, counsel for the claimant. Thank you very much, counsel for the respondent. That brings us to the conclusion of our hearing this morning, and the panel will now retire to consider your arguments.